You understand you, number one, have an absolute right not to testify if you do not want to. Nobody can force you to testify. Prosecutors can't force you to testify. I can't force you to testify. Your lawyers cannot force you to testify if you do not want to. You understand that? And you also, on the other side of the coin, you have an absolute right to testify if you want to. Nobody can stop you from testifying if you want to testify, including your lawyers. Even if their advice or their opinion is that you should not testify, you still have that right to testify, even if their suggestion or advice to you is not to testify. You understand that? Yes? I need you to answer out loud. And have you discussed that issue with your attorneys?
Yes.
And do you wish to testify or not?
Your Honor, I think there is one other issue that Mr. Merritt wanted to address before making that decision. That is the use of which priors or any priors can come in during cross-examination.
Okay,
we'd object to any. How about that?
Well, I think I remember some discussion about a burglary conviction. I don't know when it was, or if it was first or second degree.
They refresh my recollection. Well, he has a. Would you like me to work in reverse order or
I don't care.
sequential order? June 6, 1977, he was convicted of burglary at a Victorville Superior Court, convicted second degree.
Second degree, okay.
November 8th,
And do you know what the sentence was?
not handy. Those priors are sitting in my office.
Okay.
In November 8th of 1977, he was convicted of petty theft and misdemeanor. That was a revocation of probation to the burglary case, which resulted in a 2-year prison sentence. So that answers that question.
Okay.
And that was on December 14th, 1978. On August 30th, 1979, he was convicted of burglary again. 2 years were suspended with 5 years of probation.
Also second degree?
Yes. On November 3rd, 1988, he was convicted of receiving stolen property.
Wait, just a second. So the 1979 was second degree felony conviction, correct?
Yes.
And probation.
2 years suspended, 5 years probation.
Okay. Okay.
On November 3rd, 1988, he was convicted of receiving stolen property, PC 496, out of Los Angeles, where he was given 365 days county jail.
As a criminal disposition?
No, 3 years probation.
Okay. So it was a felony and he got probation.
Right. I'm sorry, there was one preceding that. February 4th, 1987, he was also convicted of 496 and was sentenced to 16 months state prison in Contra Costa County. So, 1989, he was convicted of.
Just a second. 1987, 496, state prison.
Yes.
Okay.
1989, he was convicted of possession or receiving stolen property again out of Victorville as a felony, received probation.
Okay.
September 2001, he was convicted of second-degree burglary and grand theft out of LA County, where he was given 3 years probation, 180 days county jail. This is the case that he still had active warrants for 2010 when he's interviewed by Detectives Duval and Fisk.
Okay, so he was given probation, he had custody time, and he didn't finish his custody time.
I'm not sure exactly what the natures of, I think they're all of the, it's a very long and torturous history. There were some failures to appear, there was some failure to do jail time, there were some other issues. And I know there was a violation of probation where the judge was imposing some more jail time with a surrender date that was failed to appear to. That was the active warrant in February of 2017, or 2010, or February 17th, 2010, that he claimed he would take care of the following day, which he did not, and the history continued for almost another year, I believe. I have to double check the records.
Okay,
Well,
okay.
and to remind the court, these were also subject to the People's 1101B motion should the defendant testify, given the fact they are all moral turpitude, theft-related offenses. And the court had denied that ruling tentatively, pending whether or not the defendant testified.
By 1101B, you would want to go into the facts to show that the facts of those were similar to the thefts involved from McStay?
Not just that, Your Honor, but also there was the incident involving a ticket that the defendant had received and lied to his employer about to obtain additional funds to pay a ticket that he forged the date on and things of that nature.
Oh, I remember that, okay.
Yeah.
It's 1200? I think it was to the tune of about $1,200. We have to back up the report. Right. It potentially opens the door to us with readdressing under 1101B things the court denied. But we can address that as we go.
Well, my inclination would be the 1977 burglary conviction, 1979 burglary conviction, 1987 496 that he went to prison on, and the 2001 burglary and grand theft I would allow as impeachment, as those go to moral turpitude and honesty and veracity. And I recognize, of course, the 1977 and 87 convictions are 20 and 30 years prior to 2010 and prior to 2019 when he would be testifying. And if those were the only convictions, and he had a clean record from 1979 or even 1987 or 89 onward, maybe those would not be as relevant. But when there is a continuing pattern of burglary, theft-related matters, which included 2 state prison commitments and several grants of probation, and the conduct continues, I think that is relevant in judging credibility. So I would allow those to be used for impeachment purposes. My inclination would be that the 1101B arguments as to allowing facts of those instances in to show common plan, scheme, motive, would not apply in this case. The defendant in this case is charged with murder, not with the theft of money or property from the McStays. So a string of similar thefts to show he must be the person who did the theft in this case, assuming that it was sufficiently similar to do so, doesn't really have much probative value on the issue of the homicides. And obviously it has significant prejudicial effect. So my inclination would be to not allow 1101B evidence as to the facts of any of those or other underlying instances.
Would the court be willing to consider that ruling depending on how the defendant testifies?
No, I think he needs to know that before he
Well,
testifies.
if he testifies a certain way and, indicates they have never, this
Oh, of
nothing like
course.
this has ever happened before outside of these convictions or something like that, because we believe that this murder was committed due to a financial gain to the
Oh,
defendant.
I understand that, and I understand the evidence as to allegedly taking funds either immediately before and or after the McStays were missing. I understand all of that evidence as circumstantial evidence that supports your argument that he's the perpetrator. But I think that kind of stands on its own. I don't think that 1101B evidence to show that he may have done some other thefts or obtaining money by false pretenses in the past is sufficiently probative to show, therefore, he had criminal intent and theft involved in his actions with regard to whatever he may have done with writing checks, and therefore he's the perpetrator. I don't see that connection. But obviously, if there was a definitive statement, no, I have never done this, I've never, obviously, if there's something very specific that would be impeachment to a specific bit of testimony, I would probably allow that. I would direct counsel, if that were to occur, to bring that up to the court outside the presence of the jury first for discussion before I would allow that. So you need some time to talk with Mr. Merritt?
Well, I know Mr. Merritt's one request he was contemplating was asking more time to discuss it with us further. We've been in discussion with him on this subject for some time, so if we can have a few minutes based on the court's ruling, see where we stand.
Sure.
and go from there.
Yeah, I'm going to give you a little time. Now, I need to leave this morning around 11:40, so we have about an hour. So, given the court's indication of how it would rule on the issue of priors and 1101B, certainly you can have some time to discuss that with him. We'll be in recess.